Ready? Start. These are applications under Section 389 of the Code for suspension of sentence and grant of bail to the appellants during the pendency of appeals. Stop. The appellants have been convicted and sentenced void judgment dated 24/12/2010 for commission of aforesaid offences and sentenced to undergo imprisonment for life along with other sentences. Stop. By detailed arguments and comprehensive presentation on behalf of the appellants, learned counsel for the appellants have submitted that even on merits, conviction of the appellants is not sustainable under the law and evidence collected on behalf of the prosecution is not sufficient for drawing inference that the appellants have committed aforesaid offence, including the offence of sedition, or that by their act they have excited disaffection towards the government established by law or have shown disloyalty and all feelings of enmity. Stop. By detailed submission, learned additional public prosecutor appearing on behalf of the state has vehemently opposed the applications and contended that evidence adduced on behalf of the prosecution and admission of accused persons by adducing defense witnesses are suffering to establish the fact that the appellants have committed aforesaid offence, including the offence of sedition. Stop para. At the stage of considering application for suspension of sentence and grant of bail in accordance with Section 389 of the Code, the court is not required to meticulously examine the evidence. The court is only required to prima facie assess the evidence adduced on behalf of the parties to ascertain whether conviction of the appellants is well founded on the basis of admissible evidence and whether there exists ground for suspension of sentence and grant of bail to the appellants during the pendency of appeals. Stop. At the time of granting bail to the accused during trial in accordance with sections 437 and 439 of the Code, the court is required to consider prima facie case on the basis of material collected on behalf of the prosecution at the time of such consideration, but at the time of consideration of suspension of sentence in accordance with Section 389 of the Code by the appellate court, the court is required to summarily examine the legally available evidence after conclusion of trial and pass reasoned order. Stop. At the time of such consideration, the courts have opportunity to examine and consider legally admissible evidence marshalled during trial. Stop. At the time of considering the application for suspension of sentence and grant of bail, sentence should not be suspended in a routine manner. Stop. Normally, sentence should not be suspended in cases of conviction relating to heinous offense involving capital punishment or imprisonment for life. Stop. It is pertinent to note that after conviction by competent court in elaborate trial, the theory of presumably innocent person loses ground. Stop. Section 389 of the Code deals with suspension of execution of sentence pending the appeal and release of the appellant on bail. Stop. There is a distinction between bail and suspension of sentence. Stop. The appellate court is duty bound to objectively assess the matter and to record reasons for the conclusion that the case warrants suspension of execution of sentence and grant of bail. Stop. In the instant case, the only factor which seems to have weighed with the High Court for directing suspension of sentence and grant of bail is the absence of allegation of misuse of liberty during the period the accused was granted parole. Stop.